You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford one, one will be appointed to you at no charge. We are all familiar with these rights. And generally, most people believe that these rights have to be read to you by law enforcement when you're arrested. And the answer to that is actually it's not true. That is not true. So when do the police have to advise a suspect of his or her rights? Before we can answer that question, we kind of have to go through the rights. Where do we find them? Well, the Fifth Amendment says, among other things, no person shall be compelled in any criminal case to be a witness against himself. So the government can't force you or someone to make incriminating statements against themselves in a criminal case. You have a right to remain silent. So that's where that right comes from, the Fifth Amendment. The Sixth Amendment provides, among other things that I'll get to, in all criminal prosecutions, there is a right to the assistance of counsel in your defense. But nowhere in these two amendments or in the Constitution anywhere does it mention paying for your own attorney. It wasn't until 1963 in Gideon versus Wainwright, the United States Supreme Court, where the court ruled that states are required under the Sixth Amendment to provide counsel in criminal cases to represent defendants who are unable to afford to pay for their own attorney. So that is the legal basis. Those three, that case and the two amendments, is the legal basis for the rights. However, nowhere in the Constitution and nowhere in this case does it say the police have to advise someone or a suspect of their rights, which brings us to the case of Ernesto Miranda versus the state of Arizona. The facts in this case is Miranda, who was 18, he was charged with kidnapping and raping an 18-year-old girl. He was detained by police and questioned about it for quite a few hours. I think it was like 19 hours or so, without an attorney. He had a 9th grade education and he had mental health issues. He ultimately confessed and signed a statement. In his case, he was appointed a 73-year-old attorney to represent him. His confession was used against him at his trial, which was the primary basis of the entire case. He was found guilty and sentenced to 30 years in prison. He appealed that conviction. It went all the way up to the Supreme Court. And his argument was that he was not advised of his rights under the Fifth Amendment and the Sixth Amendment and the Gideon case, that he was not advised of his rights. So what do you think the government argued? We don't have to. We don't have to tell you what your rights are. They're there. There they are. It's not our responsibility. That was one argument. And the other argument was this wasn't a criminal proceeding. This was just an investigation. Police were doing an interview. So what happened? Well, the United States Supreme Court ruled, and they actually said, no doubt that the Fifth Amendment privilege is available outside the criminal court proceeding. So that's number one. And then they laid out this test. A suspect in custody and being interrogated must be advised of his constitutional right to remain silent, that anything you say can and will be used against you in a court of law, that you have a right to an attorney to represent you, and if you cannot afford an attorney, one will be appointed to you. So they actually laid it all out. So hence, Miranda warnings, right? All in law enforcement must advise individuals of their Miranda warnings, which brings us back to the question, when? When do they have to advise someone of these warnings or these rights? Two things have to happen from that Supreme Court case. Custody. The person has to be in custody. So, okay, when somebody's arrested, we can all say, hey, that's formal. That's a formal arrest. Or if the situation creates what we call a functional equivalent of an arrest. If the situation is such that a person doesn't believe they are free to leave, then somebody is in custody. And what are the circumstances It's going to be based on case by case, but some of the courts have seen things like physical restraint, how many officers are involved, how long does the questioning period take, what time of day is it a routine type of case. So the courts will look at the surrounding circumstances and ask, would a person in that situation think they were free to leave? So custody. We have to have custody, some form of custody. But the other component is interrogated. If the police have no intention of interrogating somebody when they arrest them, then they don't have to read them their rights. It's only when we have somebody in custody and there's going to be an interrogation. And what constitutes interrogation? Police questions likely to elicit any incriminating response. It could be to direct questioning, or it could be any sort of speech or questions that the officer should have known were likely to elicit incriminating responses. So that's our Fifth Amendment right. My next question, what happens if a suspect was not advised of their rights? Well, if a court deems it appropriate, it gets tossed out, the confession or the statement that the government intends to use against the defendant gets tossed out. So we have the exclusionary rule that applies here as well. And of course, if the government has additional information and evidence that they're going to use for evidence they think proves the case, then they can proceed with the case. If it was all relying on the confession, well then likely that the case will get dismissed. Other constitutional protections. The Eighth Amendment. The Eighth Amendment is excessive bail shall not be required, nor excessive fines imposed. But the big component of the Eighth Amendment is cruel and unusual punishments inflicted. So cruel and unusual. Well, how are we doling out that punishment for doing, torture or punishing someone? Solitary confinement seems to be a big target as of recently of what constitutes inflicting cruel and unusual punishment. Sentences too severe, meaning they're disproportionate to the crime. Somebody steals a $10 item in a store and goes to jail for a year. Those sorts of things. Is the sentence proportionate to the crime? We'll see those arguments under the Eighth Amendment. Another right under our Fifth Amendment is double jeopardy. You cannot be tried for the same crime twice. That does not mean that you can't be tried in a state court and a federal court for crimes arising out of the same circumstances. That can totally occur. If there's a crime that's, let's say, an internet crime, something that's occurring, across borders or, through the internet system, that's going to be a federal crime. But if it occurs, let's say in New York State, or involves a victim in New York State, New York can prosecute under state crimes, and the feds can prosecute at the federal level. That would not constitute double jeopardy. Other constitutional protections, all of these are under the Sixth Amendment. Speedy trial. The person has a right to have their case be speedy, which is determined on a case-to-case basis. Trial by jury, entitled to have a jury of the peers hear their case. A public trial. This does not just apply to the defendant. The defendant is entitled to a public trial, but the press. We're talking about the government here, the government's action. You cannot close the courtroom to the press. We have freedom of press under the First Amendment. So public trial. And our defendant has the right to confront their accusers or the witnesses, the folks who are saying this person did that. So those folks would have to come to court and testify, and the defendant is entitled to ask them questions and confront them. So those are the constitutional protections that are afforded folks who are accused, and businesses who are accused of crimes. Our next section, we're going to start talking about specific business crimes.